continue our session this morning with Volusia County Land Trust versus Bank of New York Mellon. Counsel, can you both see the clock on the screen?
Yes.
Okay, both sides have 20 minutes. The appellant can reserve as much time as she chooses to. It's probably set to start flashing yellow when it gets to 5 minutes, but if you want something different, let me know and I'll try to remind you when you're into your rebuttal time. Other than that, just be aware that this is being live streamed on YouTube. I'm sure we have a very large audience, and we'll go from there. Counsel, whenever you're ready.
All right. Good morning, Your Honors. May it please the court. My name is Elisa Wilkes, and I represent the appellate Volusia County Land Trust, and I would like to reserve 5 minutes for rebuttal.
Okay.
This case involves the appellant not being named in a first mortgage foreclosure action and then later filing suit for damages against the bank and the appellee, Ms. Nishi, and ultimately that appellee filing a counterclaim against the appellant, my client, for a re-foreclosure action. And the issue that's before this court today is whether the trial court erred in permitting a re-foreclosure action where a foreclosure judgment was void ab initio because the legal title holder or the appellant, who was an indispensable party, was omitted from the bank's foreclosure. And we essentially have just one main point to argue because all roads do lead back to this main point, and that is that the appellant was an indispensable party to the initial foreclosure action. And because the appellant wasn't named, the foreclosure judgment is void. In our initial brief, we did provide case law that was analogous with the issues of this case, where the courts have ruled in several other cases that when the appellant brings the issue of a foreclosure judgment being void, and that is a specific issue of the case, the court has ruled that the foreclosure judgment is void for failure to name an indispensable party, and have also ruled that because of that, the resulting foreclosure sale is also void. I'm not going to rehash all of the cases that we had in our initial brief, but I just wanted to point out a few of those cases to the court. And the most essential case being in the one that's most on point with the facts of this case is the Florida Home One LLC versus Coca-Cola's case.
Ms. Wilkes, if you will, prior to going any further, I understand that there's been a original case filed and then a cross that's been filed as well. What remedy, I know that you're talking about the original judgment being void, but what remedy are you seeking from this court on appeal back to the trial court?
Well, from this court, we're seeking the remedy of reversing the decision of the trial court. Because our client's position is that because the foreclosure judgment was void, that Ms. Nishi had no standing to be able to re-foreclose because whatever interest that she received in the property is the same interest that the bank had, which is nothing because it resulted from a void judgment and a void sale.
And so do you put the judgment void as to the original borrower?
No, what I believe the case law says is that the entire foreclosure judgment is void, and that it renders the entire foreclosure action being void. That's what the court held in the Florida Homes One LLC case because of the fact that the indispensable party wasn't named. The lis pendens and everything is void. And so it's our position that what has to happen is that the bank has to bring about a foreclosure on our client. Ms. Nishi's not the proper party to do that.
Unless she gets an assignment from the bank.
Correct, but that hasn't happened in this case.
Right, but you don't disagree that if the bank were to assign whatever interest they have to anybody, that whoever they assign it to could bring the action?
No, I do not disagree with that.
Well, I think that's a pretty straightforward argument. Let's, you want to see what Ms. Lang has to say? Or do you have something else that you want to throw in?
No, that's pretty much our argument. I think that Ms. Lang has several cases that she's going to put before the court, and I will use some of my time in rebuttal to explain why they're distinguishable.
Okay, you've got 15 plus minutes left, so we'll put it over to Ms. Lang.
Okay.
Hi, thank you. May it please the court. Carson Lang, I represent the appellee Ingrid Nishi. The land trust attorney stated that the closest case to being on point in this matter is the Florida Homes versus Cocolis case. That is not the case. Recently, in June of 2020, the 4th District Court of Appeal issued its opinion in the Lucky Nation LLC versus Almagachi case. That is the subject of a notice of supplemental authority filed with the court last week. In that case, the 4th DCA, the same case that had issued the Cocolis case, affirmed a final judgment of re-foreclosure, stating that the omitted title holder had the right of redemption, and if it did not exercise that right of redemption within 30 days, its interest in the property would be extinguished. The facts of that case are nearly identical to the case currently before this court. In that case, as here, the appellants had purchased, or one of the appellants had purchased their interest in the property at an HOA lien foreclosure sale. That appellant subsequently deeded half of their interest to the other appellant. After that HOA lien foreclosure sale, the mortgagee initiated a foreclosure of its mortgage, but did not name the appellants. That suit went through to a sale, and then subsequent to that sale, the appellee, Mr. Almagachi, purchased the property. When he realized that the prior foreclosure had been imperfect for having omitted the owners of the property, he reopened he moved to intervene in the prior foreclosure proceedings to substitute himself as the plaintiff in the position of the equitable assignee of the mortgage, not based on a subsequent assignment from the bank, and to amend the complaint. In his amended complaint, he named just the omitted title holders, and then stated that he was, again, the equitable assignee of the mortgage, and moved to extinguish the interest of those two owners. The final, yes.
The Lucky Nation case still didn't address the issue that we have here, which was whether the judgment was void for failing to serve the sole record title holder in the foreclosure suit. Is that correct?
Yes, in that case, there were two owners, but neither of them were named. So it did actually, the opinion is short, it did not address it explicitly, but in that case, both of the owners of the property at the time that the foreclosure commenced were left out of the foreclosure. So when the court affirmed the final judgment the final judgment of re-foreclosure against those omitted owners, it affirmed on facts that are identical to what happened here.
And both of those owners in that case were junior holders, is that correct?
No, they were the owners of the property. Well, I mean, the court treats them as a junior interest because it states that, well, no, actually the court treated them as a senior interest because they had acquired their interest in the property from the bidder at the HOA lien foreclosure. So they took their property subject to the mortgage, but so did the land trust. So they are the owner, they are the record title of the owner in that case, as in this case, but both in that case and in this case, they purchased the property subject to the mortgage that was on the property. And in the final judgment that was affirmed in that case, again, it was just as to the omitted title holders. It gave them the right of redemption, and it stated that if they did not exercise that right by paying off the judgment, then their interest in the property was extinguished. The only thing that the 4th DCA had reversed in that case was the amount of the redemption, which the land trust has not raised issues about the amount of redemption here. And so that's not an issue in this case. The fourth DCA's opinion is the closest and the only case that directly addresses this issue in Florida, but it's supported by case law from both the Supreme Court and this court. As far back as 1912 and 1915, in a pair of cases, Key West Wharf versus Porter, and then Crystal River versus Knight Turpentine, the court recognized that if a foreclosure is imperfect for any reason, then the purchaser at the foreclosure sale becomes subrogated to the rights of the mortgage and the mortgagee, and has the right to foreclose out, to extinguish that emitted interest. In the Crystal River case, the person that had been emitted from the foreclosure had an ownership right in the property. They didn't own the land, but they owned the timber rights on the property and had been foreclosed.
Let me ask you about the Crystal River case. In a subsequent case called Stewart versus Gaines in 1931,
yes,
the Supreme Court summarized its holding in Crystal River and said, when for any reason foreclosure proceedings are imperfect, irregular, or void, a re-foreclosure may be had by the purchaser at the sale against parties holding junior encumbrances who've been omitted. I guess my concern there is they specifically said against junior encumbrances, not against senior encumbrances. And I'm concerned, you know, when you look at the case that Judge Gross wrote out of the Fourth, where he said it's void and a purchaser acquires nothing if you leave out the sole title holder. If you read that in conjunction with this case that talks specifically about junior encumbrances, where does that leave us with respect to this situation?
two things. First, in the Stewart v. Gaines case, the facts of that case, even though the court in summarizing Crystal River stated against junior encumbrances, the issue in Crystal River was an ownership right. Additionally, in Stewart versus Gaines, the party that had been left out is described as having, and the interest of the Stewarts exists in only one lot out of 16, and that interest is an equitable one under their contract of purchase from the mortgagor. So they were not a junior lien holder on the property. They were a party, even though it says a contract for the purchase. I'm not sure if that contract had not, the purchase and sale date hadn't passed, but they were an owner. Additionally, in the Cocoless case, the fourth DCA did not state that the purchaser didn't get anything. Rather, and I think it's the last paragraph of the case, the court said that they were the successor in interest to the mortgage and that their rights were superior to the omitted party. So in fact, in that case, in the Cocoless case, the court didn't address the issue that's before this court. What the court was talking about was whether a lis pendens that had been issued in that case was sufficient to basically extinguish the interest of the omitted party, because in that case, the facts were a little bit convoluted in that the party on the certificate of title was not the right owner. So when the foreclosure suit was filed and the lis pendens was recorded, the actual owner didn't have a certificate of title. Their certificate of title was recorded after the lis pendens. And so on appeal, the argument was made that they fell under the lis pendens rule and their interest was extinguished by that. The Cocoless court said—
How do you address an even older case, the Jordan versus Sayre case? Basically, if you get a judgment without the holder of the legal title being before the court, it has no effect to transfer title to the purchaser at the sale.
Yes, the case law does establish that Ms. Nishi did not have clear title to the property, but the case law is clear that she was subrogated to the rights of the mortgage. The land trust position here is that Ms. Nishi did not acquire any rights as to the party or as to the property, but she was able to stand in the shoes of the mortgagee and exercise their rights under the mortgage. In other words, to re-foreclose. So when the case talks about how she did not acquire title to the property, yes, she did not have clear title to the property, but she had acquired the rights with which to clear her title to the property, and that's what happened. I'm sorry, you're on mute. Judge Wallace, you're on mute.
Sorry.
That's okay.
The re-foreclosure action is specifically limited to the junior lien holders and not the sole property owner, correct?
No, that is not our position.
Okay, explain, please.
Yes, the re-foreclosure, and by re-foreclosure, the distinction between the case law that says action de novo and re-foreclosure is kind of a faulty distinction, first of all, because in several cases, the Quinn Plumbing case and the Abdoni case, Quinn Plumbing is from the 30s, Abdoni is from the second DCA in 2005. The court recognizes that the remedy against an admitted party is either to compel redemption or to start from scratch. When we speak about re-foreclosure, what I mean is extinguishing the interest via a final judgment that states that the admitted party can exercise their right of redemption or else be extinguished. The Fourth District Court of Appeal last month affirmed such a final judgment of re-foreclosure against an admitted title holder. Additionally, in the Crystal River case, as well as in the Stewart case that we talked about earlier, the interest was an ownership interest in the property. Subsequent to both of those cases in the 90s, this court in Commercial Laundries stated that a leasehold interest is subject to re-foreclosure. That wouldn't be a junior encumbrancer, that's a leasehold interest. And part of its reasoning was based on these older cases and stating that if a real property interest, such as an ownership interest, can be re-foreclosed, so too can a leasehold interest. So it is not true that a leasehold or that a re-foreclosure is only available where a junior lien holder is admitted. That's the most common way that we see re-foreclosure done, but it is not limited to that right. And the first cases that talk about re-foreclosure state if for any reason the foreclosure was imperfect, then this is a possible remedy. The party seeking to clear title can either start from scratch or seek re-foreclosure. And our position would be that in this case, the most judicially efficient thing to do was to re-foreclose. Importantly, the land trust had actual knowledge that the foreclosure was taking place before the foreclosure sale and elected not to intervene to either raise the fact of its omission or to raise defenses to foreclosure. The land trust states that they sent letters to the bank, but they elected not to use any legal remedy to step in and to stop it.
Well,
Rather,
but who had the greater burden? I mean, the bank clearly, let's face facts. I mean, the bank should have checked the title a little bit more carefully. I hope that some title agent has tightened up someplace over this. I mean, this was not a model foreclosure, and I don't know that land trust had any legal obligation to jump in. I mean, wasn't
yes,
it it was the bank's obligation to invite them to the party, not the other way around.
Yes, it absolutely was. The bank messed up, and they should have named the land trust, and that's why the foreclosure proceeding was imperfect, and that's why Ms. Nishi is now in the position of having to fix what happened.
I guess the concern that I've got here is whether this is an imperfect foreclosure or a void foreclosure. You know, in the Quinn Plumbing case, they say that it's well established that the purchaser of a property at a foreclosure, when for any reason the sales are imperfect or irregular, becomes subrogated to the rights of the mortgagee. But interestingly enough, they specifically don't use the word void. And so I guess the question is, you know, is it your contention that this is merely an imperfect foreclosure, or is the judgment void? Because Quinn seems to limit that equitable subrogation to imperfect or irregular as opposed to void.
The Crystal River case states imperfect, irregular, or void. So in that case, the Supreme Court recognized that even a void foreclosure. My position is that I've said imperfect, whether it's void or not, Ms. Nishi, as the subsequent purchaser, gained rights vis-a-vis the property. She is subrogated to the rights of the mortgagee under the mortgage. One of those rights is to re-foreclose the property. If we were to do this foreclosure sale, this foreclosure proceeding from scratch, then the result would be exactly what happened here, that the land trust would be given the opportunity to pay the foreclosure judgment or else have its property, or else have its interest in the property extinguished. And that's what happened here. I agree with what you stated earlier. I don't think that the land trust had any legal obligation to intervene in that case, but certainly if it had any defenses to foreclosure, it should have raised them. They haven't been raised in this case. The only objection that the land trust has is not with the result of what happened. It's conceded that its interest is subject to foreclosure. It only takes issue with the procedure by which we got there. They would say that the only way to do it is for the bank to redo the foreclosure from scratch. Ms. Nishi is now the owner of the property. She can't force the bank to do that. She's exercising the rights that she has, having purchased the property and being equitably subrogated to the rights of the mortgagee under the mortgage. Neither the case law nor neither the most recent case law that's on point, nor the interests of judicial economy require or would support starting from scratch in this case. If
we see it your way, counsel, are we in conflict with English and Villanueva out of the fourth and Florida Homes?
No, because in those cases, the court did not address reforeclosure. In the English case, the issue was whether the principle of res judicata prevented the court or prevented the subsequent owner from renaming the original mortgagor. And the court said, no, it's redundant to name her probably, but you can. In the Villanueva case, the issue was whether the trial court had erred in not permitting the bank to start over. The bank had moved to vacate its judgment so that it could start over. It elected that remedy, and the trial court said no, and the fourth DCA said that was error. The Cocolis case only had to do with the effect of the lis pendens, but subsequent, I don't think it would be in contravention of those cases, because subsequent to those cases, the very same court, the fourth DCA, in the Lucky Nation case, affirmed a final judgment of reforeclosure against an admitted title holder. The Cocolis opinion suggests that the subsequent purchaser acquired rights superior to the admitted owners, and then the fourth DCA the next year in 2020 took that a step further and said the rights include the right to reforeclose.
All right, anything further?
There is nothing further. If the judges don't have any further questions, that's all I have. I would just ask that the court affirm the trial court's judgment of reforeclosure.
Okay, thank you so much. Ms. Wilkes, you've got 15 minutes remaining. Let me ask you, is Ms. Nishi equitably subrogated to the bank? And if not, why not?
No, we believe that she is not equitably subrogated to the bank because of the fact that the foreclosure judgment and the sale was void, and there has been no assignment of the bank's interest of the note and the mortgage to Ms. Nishi.
Well, how do you distinguish it from Stewart v. Gaines, where they left out the owner of one of the lots, and they said that a subsequent foreclosure was okay in that case, and that the purchaser at the sale of all of the lots, included the one where they omitted the owner, was equitably subrogated to the original party?
Well, I would argue that that case is distinguished because it was a case that involved equity and marshaling of assets involving a contract vendee and not necessarily a title holder of the property. And they also did not address the issue of whether the original foreclosure judgment was void, and who could re-foreclose or how that could even be done. That was not addressed in the Stewart v. Gaines case.
Ms. Wilkes, could you respond to the appellee's comment that re-foreclosure is a proper remedy as it concerns a sole property owner or a fee simple property owner?
Absolutely. I have not found any case law that states that when there's a void judgment, that a re-foreclosure of a legal title holder is proper. The only case law that I have read and have seen says that a foreclosure is against a legal title holder is de novo. And I think the only person that can, or the only entity that can bring that foreclosure is the bank, because of the fact that it has to include what our statutes say that it has to include today, which is a verified complaint. It has to include a lis pendens. There was no lis pendens filed in this cross complaint against my client. There was no verified. The cross complaint wasn't verified. My client has an opportunity to defend. My client wasn't given that opportunity because of the fact that when the cross complaint was filed, we filed a motion to strike it as a sham pleading because Ms. Nishi didn't have standing to bring that action. And instead of the court ruling for or against that motion and allowing the case to move forward, it also then immediately ruled on Ms. Nishi's motion for summary judgment, which didn't allow my client an opportunity to defend. So I disagree with counsel that the results would be the same because the fact that there also needs to be a foreclosure sale against the legal title holder and not just in a right of or an opportunity to provide any kind of redemption. My client's also entitled to surplus and is entitled to the stirring up of potential bidders, which can lead to that surplus. My client didn't have that opportunity. So for those reasons, no, I do not believe that re-foreclosure by Ms. Nishi is appropriate or what is permitted under the law.
How does a re-foreclosure differ in substance versus what was done here as a counterclaim? I mean, what's the difference?
The difference is
an independent lawsuit. Wouldn't it have just gotten consolidated with this lawsuit?
Well, I don't agree that Ms. Nishi could ever bring it. I think it would have had to been the bank. And I'm not arguing that no one can foreclose against my client. That's not the argument here. But re-foreclosure is, as the case law has shown us, is only against an omitted junior encumbrancer or a junior lien holder and provides an equitable right to redemption. That's the only thing that a junior lien holder is allowed, that a legal title holder is entitled to have its day in court and to have all of these things happen, the complaint, the opportunity to do discovery, the sale, all of that.
Well,
so
I guess what I'm trying to get at is I recognize that this foreclosure that Ms. Lang's client obtained, like most, went by summary judgment. But why weren't you allowed to do discovery and do whatever you wanted as part of that lawsuit? I understand the technical objection that you didn't think she was the right party, but laying that issue aside, how were you precluded from doing discovery and doing whatever else you wanted prior to the summary judgment?
Well, I think that we were never provided that opportunity because the court immediately shut it down with ruling on Ms. Nishi's motion for summary judgment. But
did you move to continue it? Say, look, Judge, we got to do some discovery.
We did not, because he issued a final order in that case. But the other thing is also that if Ms. Nishi is going to step in the shoes of the bank as an assignee, they have to prove up the defense or the foreclosure itself. And that was not done in the counter complaint. There was no you know, this is the amount that the bank is seeking, and this is the past due payments, and you know, here, all of the typical things that are done in a foreclosure action, none of that was done in the cross complaint for re-foreclosure. And so we don't believe that it was properly done.
All right, anything further?
Yeah, would you address Lucky Nation, Ms. Wilkes? And the facts of that case are sparse, but it does seem that there's a sentence in there that suggests that neither of the appellants in that were named in the initial foreclosure suit brought by the bank, which would seem to at least cause some confusion about the Fourth's previous cases in English Villanueva and Florida Homes, and seem to suggest that the appellee's position is meritorious. Could you address that for us, please?
Yes, Your Honor. First off, as you've stated, there's not a lot of facts. It's a very short case opinion, so I don't know all of the detail. It was not provided by the court, but for whatever reason, the court held that these were junior lien holders. So there could have been some contract interest or whatever it was that they had in the property. That court treated them as
Well,
junior.
one of them was the HOA, right?
I don't believe that one of the defendants.
Lucky Nation?
Let me check. Lucky Nation and Nina Solaneko.
Lucky Nation obtains its interest through a foreclosure of the association lien.
Right. The
And
other
Go ahead.
issue with this, I think, is the fact that they were post-list pendants purchasers. I'm looking through this. The other thing that's notable to me in this case is the fact that it didn't overturn. The Fourth DCA did not overturn the Florida Homes case in this argument. But there also was, or in this
I
opinion,
mean, they wouldn't have really, it's two completely different panels issued a month apart. Is it more plausible that one panel just didn't know what the other one was doing?
it's possible. The other problem we have here too is that this case is less than 30 days old. So we don't know, and perhaps there's an appeal to the Florida Supreme Court on this. I don't know. It does say that it's not released for publication until that time period has run. So I'm not sure that it can be binding authority on this court, given the age of the opinion. But I think the main distinction here with the Lucky Nation case is the fact that these purchasers bought the property after, or that the certificate of title was issued after the list pendants was filed, where in this case at hand, my client had title to the property before any list pendants was filed by the bank.
The list pendants is designed to give people notice who wouldn't otherwise have notice. I mean, presumably your client was in position to know that that first mortgage was out there.
That's correct.
I mean, I just don't see in this case, I mean, there's no requirement. You're permitted in a foreclosure to file a list pendants, but you don't have to. I mean, you take the risk that post list pendants folks might not get notice of it. But pre-list pendants folks aren't impacted by it at all. And so even if there had been a list pendants in this case, it wouldn't have affected anything because that first mortgage is still a first mortgage.
Yes, I agree that the first mortgage is there and that my clients took subject to the first mortgage. I don't think that eliminates the need for the foreclosure to be done properly.
All right, anything further, counsel?
No, I do not believe I have any further argument.
All right, judges, anything further? All right, well, I want to tell you both, I thought that your briefs in this case were some of the best I've read in quite a while, and in 20 years I've read a lot of briefs. And although the topic here isn't the most scintillating in the world, I thought they were very well written. So thank you both.
Thank you very much.
Thank you.
All right, counsel, stay well, have a good day, and we will be in recess till our 11 o'clock case.
Thank you.